Welcome to Rethinking Trade with Lori Wallach, a podcast that unpacks international trade and how it affects you without putting you to sleep.
Welcome to Rethinking Trade with Lori Wallach. I'm Lori Wallach. Today, we're going to make a topic that we've talked about in the past, digital trade, very concrete, and we're going to hear about how all of this talk about digital trade and big tech lobbyists trying to rig trade agreements to undermine oversight of platforms and undermine our privacy protections, how it's really coming home. At Rethink Trade, we have found 100 state laws, many of them passed, a bunch pending, in 42 states that could be undermined if the big tech firms get their way and put these so-called digital trade rules into effect across the world. This research is fantastic. We have just published at Rethink Trade this very cool feature on our website that uses maps, so you can click on your state to show your state's laws that deal with big tech abuses relating to online safety, right to repair, the discrimination, and other problems, and what could happen with big tech's push to get so-called digital trade rules, limits on regulation. On our website, the part you want to look at says, Big Tech's digital trade agenda threatens states' tech policy goals. You can go there to the maps, you can get the background, but better, let's hear it live. I'm thrilled to introduce two of my colleagues. Katie Hettinga is our program associate, and Danielle Rangel is our research director. To learn more about Katie and Danielle, please go to our website and check out their biographies. Hello to you both.
Hi, Lori. Good to be here.
Well, happy to join you, Lori.
So let's start with Danielle. So what exactly are we talking about with this body of work, but also practically what it means for people's lives?
We decided to start this project because many people think about the interaction between federal law and trade agreements, but there's few people that are aware that anything that the federal government negotiates also binds what state and local governments can do. Under the World Trade Organization, you can challenge the policies that another country adopts. And this goes through a tribunal of 3 trade experts that are going to assess whether the specific policy is consistent with the WTO agreements. If the panel determines that there is an inconsistency, then it could authorize sanctions against that country. And that's what often leads governments to either pull back or water down policies, and in some cases, public interest policies.
How does that relate to digital trade or to online stuff?
Trade agreements have been the vehicle to include rules about a lot of different policy domains that are not actually about trade. And the latest area that has experienced this trend is what is now called digital trade. It's hard to see how it's related to actual trade, but what these rules would actually do is to constrain what governments can do in terms of tech policy. So in the US context, we have seen that it has been very hard for Congress to pass federal legislation to either protect people's privacy or guarantee that AI systems are actually not biased and are accurate and do what they're intended to do, and all sorts of things. So what has happened is that state policymakers, they have stepped in and they have been the ones that have started putting together regulation and actually passing it. And here I would love for Katie to let us know a little bit more about what we found for the state regulation for the tech sector.
Absolutely. In our research, we found over 100 bills introduced in 42 states and Washington, D.C. in recent years that may be at risk of challenge because of these digital trade rules. In the areas of AI regulation, right to repair, kids' online safety, and data privacy, there are many bipartisan policies in many different states that state lawmakers may not know could be blocked or challenged by digital trade rules.
So basically, this is the thing we've been talking about of lobbyists for big corporations who can't get their way in the sunshine of normal debate using trade agreements to do some kind of a international preemption move. and sneak bad policies in the back door. And that's really kind of terrifying to hear it's 100 policies, because we do see the big tech lobbyists blocking everything in Congress, but the states have been doing some really exciting stuff. So I'm wondering, Daniel, if you can give us some examples of the kinds of conflicts that could arise. And then, Katie, I'm going to ask you to give us some examples from that tracker. But again, folks, go to the website, www.rethinktrade.org/digital trade. And you can look at your states also once you hear the rest of the podcast. So, Daniel, what are some of the problems?
So let's start with AI regulation, because it has been in the news. But actually, for many, many years, there are groups that have been calling for algorithmic transparency or AI accountability. And this came after the realization that algorithms play a very important role in our life, from determining whether someone gets hired or establishing the amount of rent that you pay. And in this context, what digital rights groups have been calling for is for having some kind of independent evaluation on the algorithms that determine so many facets of our lives. And that could be either by an independent audit, or it could be by giving access to the algorithm and even the code that is behind the algorithm to regulators. It could take different forms. But in the end, what we want is more transparency on these systems. And the problem with digital trade rules is that there is one of these terms that has been promoted by tech companies that establishes a layer of secrecy over the code and the algorithms. Basically, it will forbid governments from requiring the access to or transfer of the algorithm or the code that runs the algorithm of any kind of software. And that's where we see a big problem in terms of algorithmic transparency and accountability.
So, Katie, what are some examples of existing or proposed state laws that could run into this?
One example, and actually one of the oldest bills that we looked at in our tracker research process, is an Idaho law on pretrial risk assessment tools. This law took effect in 2019, and it requires that when courts in criminal cases use some sort of automated or algorithmic tool that uses data and training sets to present to the court evidence that a certain party to a criminal case may be at risk of not appearing in court or may be at risk of committing another crime, the risk assessment tool that's used must be transparent. Parties to the criminal case must be able to review the training sets and the data that are used to calculate this risk. Other AI bills that we highlighted outside of just this Idaho example include requirements to submit training data and design information to public registries or government officials. Some bills require that employees disclose when they are using AI tools to their employees, and other bills may require AI developers to conduct impact assessments and then share those assessments with people who are using their AI tools.
So that seems like the important stuff. If there's going to be some application online that's going to decide if I'm getting bail or not, or if I'm going to get a raise or get fired, it seems pretty obvious that you need to be able to check into what those decisions are based on. So those state laws could be undermined by these proposed rules. What else, Daniel, are threats?
We recently saw how Instagram announced that it was going to change some of its privacy practices to protect kids online. And that goes from not sending them notifications from 10 p.m. to 7 a.m. so that kids can actually sleep, or having all of their accounts with a private setting as default. But people question if that's going to be enough. And some policymakers have said that it's important to require independent algorithmic audits or impact assessments of these kind of tools that are being used by kids, but honestly by everyone. And we have found some interesting bills that will actually conflict with this idea that the source code and the algorithms should be kept secret.
So, Katie, what are some examples? Where is this a problem?
One really good example is in Texas. In 2023, they passed the Securing Children Online Through Parental Empowerment, or SCOPE Act. It took effect September 2024. This act requires digital service providers, so these social media companies that Daniel is talking about, to make their algorithmic code available to independent security researchers in order to specifically prevent children from being exposed to harmful content online. So any of these bills where algorithmic code has to be handed over to government officials or independent researchers may present conflicts with digital trade obligations. Other states like California, New Mexico, Illinois, and South Carolina all similarly require social media corporations to submit data protection impact assessments to state officials.
I understand that also the right to repair is impacted. Folks, you recall we just had a really interesting conversation with Nathan Proctor from the organization PERG. Listen to that one if you didn't catch it, about the right to repair and how that be implicated.
The idea that the government cannot require access or transfer of the source code will also cover mandating access to third parties. One key element of all of these right to repair laws that have been making progress at the state level is to guarantee that manufacturers share all of the information, tools, and software that is necessary for people and independent repair shops to conduct repairs. And since we live in a digital world, in a lot of cases, those kind of tools are even the diagnosis software or the firmware, which is like the piece of code that connects a device with a part, or even the digital key that will unlock the possibility of actually repairing your device. And those pieces of information are algorithms, because if you look at the definition of algorithm under digital trade agreements, it's basically a sequence of steps that leads to a result. So any of these tools will be an algorithm, and then asking these companies to share those tools with third-party people, consumers, and with independent repair shops, well, that could be interpreted as a violation of this rule.
States have really gotten into this first because, for instance, people in rural parts of the country buy a very expensive tractor, something goes slightly wrong, they fix that same thing over and over on their past tractors. But now suddenly, because it's not a matter of just like replace this part, but the part has to be read by the master computer. We've seen this with our cars. How many people have gotten a part from a junkyard and put it in, but you can't make the computer in the car recognize it? So these are very practical things that affect us all day to day, and it's everything. It's our phones. So Katie, what are some examples of states guarantee us these rights as the owners of our stuff to actually make the stuff last and get fixed?
In our research, we found that just in the last few years, there have been 60 right to repair bills considered in 38 different states. 8 of these bills are already signed into law and taking effect soon, if not already. One example is Minnesota's 2023 Digital Fair Repair Act. This bill covers all digital electronic products used for personal purposes. It does not include agricultural equipment or motor vehicles, but another bill that was considered in the 2024 legislative session was specifically for ag equipment in Minnesota. The conflict posed by digital trade provisions is because manufacturers have to share information used to repair these digital electronics. Some other repair laws in other states are restricted to specific types of products, things like powered wheelchairs, motor vehicles, motorcycles, and agricultural equipment. And like you said, Lori, when any of these products are internet connected or have some type of software component, there will be source code disclosures to make repairs.
So that's very concrete, and yay, the states are starting to get that work done. Daniel, what else? What else are the states doing?
So something that is important for many state policymakers is personal data protection, data privacy. And most of these states have been focusing on passing personal data protection laws that basically will give people rights to opt out of data collection. In the less strict version, but in the more stringent requirement, it will ban companies from collecting a lot of information, and it will require them to collect only the information that is really necessary to provide the services that they do. That's called data minimization. But what we have seen that is very interesting is that some states have gone a step further. They have imposed certain limits on the movement of data across borders, even within the United States. Okay. And here the problem is that a key goal for lobbyists is to get a prohibition on any kind of regulation or what they call it restriction on the cross-border movement of data. And in that way, any kind of policy that could be interpreted as a restriction on the movement of data across national borders, but it could even be subnational borders, then could be challenged as a violation of this digital trade law. So, Katie, why don't you give us some examples of what we found?
Both California and Maryland have similar laws that require that information about sensitive medical services, things like gender affirming care and reproductive services, that information is not transferred to entities or individuals that are outside of their respective states. But a very different example is Montana's Genetic Information Privacy Act, which came into effect during 2023. And this aims to keep Montana's genetic data out of the hands of foreign adversaries. So when you send in your spit in a cup for Ancestry.com or something, that data cannot be held outside of the United States in countries designated as a U.S. foreign adversary.
Very interesting. Listeners who have been hearing about digital trade and wondering what the hell we keep talking about, this just got really real. These are laws all across the country that can very intimately affect your daily life. A bunch of them we're hearing from my colleagues are in effect. These are laws now shaping your life. A bunch of them are proposed. We certainly need a bunch of these laws. And whether or not we have these digital trade rules that the big tech lobbyists are pushing for every part of the world to be submitted to is going to make a real difference in our day-to-day lives. So I really appreciate my colleagues having done this hard research and bringing this all home to very concrete examples. I urge everyone to go online, take a look again, rethinktrade.org/digital trade. You can go into the map, click in your state. It's translated out into what it means directly for your life. Spread the word, because the way we're going to make sure that these bad rules don't get put into trade agreements all around the world is by making sure everyone understands what it means for their lives. And it's not good news, as this new project makes very clear. So thank you very much to Daniel and to Katie for their hard work and for helping bring this all to our attention. And until next time, thanks for joining us. It's Lori Wallach signing off for Rethinking Trade with Lori Wallach.